Hey folks, my name is Jim Aspel. I'm a board certified workers' compensation attorney in Farmington, Connecticut. And today I wanted to talk to you about the question of causation in a Connecticut workers' compensation case. It's a topic that arises quite frequently. It's one of those words that workers' compensation lawyers toss about, and clients a lot of times don't actually know what it means. So the word is causation, and essentially what it means is what we're trying to ascertain is whether or not, in the opinion of the doctor that's taking care of you, your work activity was the cause of the problem that you were having. Now, we frequently see this in repetitive trauma claims where we're alleging that somebody's repeated work activities are the cause of an epicondylitis or a carpal tunnel syndrome or something like that. And typically we know that that's the case, but we need a medical opinion. So in any legal proceeding, you need evidence in order to put on your case. So in that case, we write to the doctor and we say, dear Dr. X, I'm representing your patient, Mrs. Y, and we're trying to find out whether or not you feel, in your opinion, her work activities, and we set out what those happen to be, were a substantial contributing factor in bringing about the condition. So in other words, bringing about the carpal tunnel or the epicondylitis or whatever it happens to be. And the doctor is going to write us back and they're going to answer that question yes or no, or I can't tell. That report is what's called a causation report. And if the doctor writes back and says, yes, Attorney Aspel, I believe to a reasonable degree of medical probability that Mrs. X's work activities were a substantial contributing factor, then we in fact have causation and we're free to move on towards prosecuting the case. Frequently we see this in back cases as well. A lot of times with construction workers or something like that, there's a lot of repetitive lifting or a lot of repetitive twisting and bending that's associated with the job. And the question becomes, well, was that the cause? Was that the reason that the person has now sought treatment or become unable to work? And again, we have to write to the doctor and we say, we're representing your client. They've been engaged in the construction field and they're frequently lifting heavy loads, or they're repeatedly lifting and twisting. Do you feel that that's a substantial contributing factor in bringing about their work-related injury? And again, the doctor is going to give us a causation report. Assuming the doctor answers yes, then we're free to proceed with putting on the case. If the doctor does not give us causation, and sadly that is sometimes the case, then there really is not a lot that we're going to be able to do for you. You need to have that causation as a threshold piece in order to move forward and bring your legal claim for workers' compensation benefits. So what's the standard for causation? Believe it or not, it's actually not that high. In Connecticut, the work activity has to be what we call a substantial contributing factor. It doesn't have to be the only factor, just has to be a substantial factor. So you could have 10 reasons why your back hurts, and so long as your work activities are a significant part of those 10 reasons, then you've got a substantial contributing factor. And I like to define it as more likely than not. So if your work activities are, in my opinion, more likely than not the cause of your problems, then you're going to have causation. So think of the causation as a threshold issue. We see it, like I say, in repetitive trauma claims quite frequently, both hands, elbows, shoulders, and backs. Occasionally knees, but not all that often. And then sometimes what you'll see it in is a situation where somebody has a pre-existing condition, and then they have some activity that happens at work, whether they're lifting a box the wrong way or they're catching a patient who's falling or whatever it happens to be. But the person, before they came to work that day, had a pre-existing condition. Then we have to ask the doctor, was the work activity the cause? Was it a substantial contributing factor for bringing about this need for treatment or this inability to work or whatever it is the particular benefit that we're trying to claim on behalf of our client is? So that's another instance where causation would come up, the field of pre-existing conditions, and that's a whole video in and of itself, I would say. The notion of causation is so important both in medical and legal circles. The American Medical Association actually puts out a book to help doctors understand what causation is and how it interplays with their treatment and their role in the medical legal process. So if you have any questions about that, and I know it's still probably confusing, but if you don't have causation, you really don't have a workers' compensation case. Just because something happened while you were at work doesn't necessarily mean it's compensable. The work activity has to be the cause of your problem. And maybe that's the simplest way that I can say it, and I should probably get out on that note. If you have any questions about that, or you're having difficulty getting causation, or you want to know how you get causation in your Connecticut workers' compensation case, give us a call. We're in Farmington. I'm happy to help you out. 860-523-8783. You can visit our website. It's www.ctworkinjurylawyer.com. There's tons and tons of information out there on all sorts of topics, pages and pages, and you can probably find the answer to just about anything there. But again, I'm more than happy to help you. If you found this video even slightly helpful, I'd appreciate it if you would give it a thumbs up. I'd invite you to subscribe to the channel. We're putting out lots of good Connecticut workers' compensation topics as frequently as I can. And again, happy to help any way that I can. Farmington, Connecticut, 860-523-8783. Thanks very much.